Dale, welcome to the program this evening.
Thanks for having me, Rebecca. Yeah, we actually have some good news. The U.S. Court of Appeals for the D.C. Circuit ruled in our favor this past week that our lawsuit that challenges one of these unlawful guest worker programs can go forward. And the district court had ruled against us, stated that American workers do not have standing, have not been injured by the creation of these guest worker programs, and also ruled that we had not pled an adequate cause of action. Well, the D.C. Circuit reversed that last week and remanded the case to the district court to hear our claims.
So now tell us what this program is that you challenged. What is it's? I believe I'm reading your press release on it. It says it's the optional practical training, the OPT. Tell us about this and why you challenged it.
Right. This rule came about, actually, its genesis. The rule was instituted in 1992 under the Clinton administration. And what it did was it allowed foreign national students who have graduated to remain in the United States on their student visa. They're no longer students, they've graduated, but it allowed them to stay in the U.S. for a year. Well, sadly, the Bush administration doubled down on that in 2008 and amended the rule to allow anyone pursuing a STEM degree, which is science, technology, engineering, or mathematics degree, to stick around an additional 17 months. So basically, this is an H-1B worker, guest worker, which is in law. It's a workaround on the cap that Congress set on H-1Bs. H-1Bs are capped at $65,000 a year, and Congress has thrown in another $20,000 for high-tech STEM degrees. But there is a cap. Well, tech companies, as you said, Silicon Valley, they've lobbied and lobbied and lobbied these business-first politicians to get more guest worker visas. Because they don't want to pay Americans the prevailing wage. Guest workers obviously will take lesser pay and lesser working conditions than Americans will. So that's why this program was created. And we challenged, actually, the 2008 rule. We brought a lawsuit in 2014 and challenged this one and got it struck down in 2015. And then Obama turned around in 2016 and reissued the rule. And not only did he reissue the rule, but he increased the time, the extension that STEM workers could have from 17 months to 24. So potentially, graduates, foreign national graduates, who are here on an F-1 student visa can potentially stay in the country for 3 years on that F-1 student visa. Whereas under law, under the INA, they should go back to their country. They should go home.
So now I'm going to play devil's advocate because I have to. So let's say, a devil's advocate, you'd say, okay, well, these people just got a STEM degree in the United States. Why wouldn't we want to keep that talent here? They'd say, right? That's what the Silicon Valley would say. Hey, these are. Let's say it's a Harvard-educated engineer who's going to be doing amazing things. This could be the next guy that develops the new Facebook or something. Wouldn't we want to keep that individual in this country?
Well, there are several arguments to that point. Number one, brain drain. These people come here, and a lot of times from third world countries, when you look at the statistics, India has the most OPT, optional practical training, recipients. So these countries are in desperate need of those highly educated individuals to go back to their country to help reform, to help make that a better place, or else we're going to have this continual stream of people trying to leave those countries. So it's the compassionate thing to do is to have them go back home and care for their own people. But number two, and more importantly, American STEM workers, American workers are being displaced in favor of cheaper labor. So, we represent in this lawsuit that we've discussed American workers who can't get jobs at Microsoft or these big tech companies because they prefer the cheaper labor. And there are several aspects of this OPT program that make it more attractive to companies. For one, the company doesn't have to pay the employees' Medicare and Social Security taxes. Every employer has to pay half of an employee's Medicare or Social Security tax, but that's not true for OPT. So these companies benefit right away from hiring non-Americans. There are plenty of Americans out there in the STEM field who are underemployed or unemployed. There is no shortage.
I'm going to play devil's advocate here, and perhaps in a sense I'm the devil because I actually believe what I'm about to say. But I don't have much sympathy for the brain drain argument. I understand countries are worried about losing skills, but I think those countries have to step up their game. I think they should compete with us to attract those skills. I don't think we need to worry. I think we need to be hyper competitive for the best skills in the world, especially as we're competing in a geopolitical sense with some of these countries like China and Russia. We want their most talented people here. We don't want them over there building spyware and whatever in Moscow computer labs or somewhere in Beijing. I think that other countries, I'm from South Africa originally. I was born there. I grew up here. But I think that other countries have to make it more attractive for talent to stay where they are. The brain drain in South Africa isn't just a pull factor, people going overseas to the United States, the United Kingdom, and so forth. It's also a push factor. If South Africa took steps to address crime, if they got rid of some of the onerous regulations in their country, if they scaled back some of the hyper-ambitious affirmative action policies, they would keep more of their skills in the country. And those are things those governments should be encouraged to do by the threat of talented people leaving. I want you to respond to that. And then I have another point about the OPT visa, which I have some indirect experience with. But let me hear your point, first of all, about the brain drain.
Well, I absolutely agree with you that these governments need to make their countries and institute reforms that make their countries more attractive. I don't disagree with that. However, our interest here, and the current president has said, "Buy American, hire American," and my interest is in representing our technology workers who have been displaced, and we represent, as Rebecca started off this segment with, there have been workers displaced at Disney, and Southern California Edison was another example, and we actually represent several of those employees in another lawsuit regarding the H-4 visa. These measures, and the H-4 visa, if I can, is H-1B guest workers, their spouses are here on H-4 visas. Well, they've never been allowed to work in history since the H-4 visa was created. But under the Obama administration, they instituted a new rule where they are allowed to work, and we are currently challenging that in federal court also. These are just these are guest worker programs. The Silicon Valley and these greedy companies are not getting the number of H-1B visas that they want. They've pushed legislation for years. The American people and their representatives have said, no, we're not going to increase it. And this is a workaround, plain and simple. In fact, the 2008 rule, the Bush rule that I had mentioned earlier, its genesis was from a dinner party that the DHS secretary at the time was approached by Microsoft at a dinner party, and they were lobbying them to increase it, and they came up with this rule and said it was an emergency. And we have all these displaced STEM workers, Americans, and it's just plainly not fair. And if you look at the numbers, between 2004 and 2016, 1.5 million foreign graduates have taken advantage of the OPT program. And since that 2008 Bush rule, the OPT program grew by 400%. So
now, let me just speak. As someone, I've known a few people on the OPT program, and the OPT program allows students to stay on, I believe, an extra year and work for companies in America. But if they don't have a job, they get sent back. And if they're here outside of the 3 or 4 week window where they're allowed to be looking for a job, if they don't have one, if they overstay that, then it's almost impossible for them to come back into the country. Basically, they violated the terms of their visa. So there is some enforcement there or at least room for enforcement if we're not following that closely enough. But let me just pose this question to you. Aren't there circumstances in which we get an exceptional graduate from overseas who studies here, who brings unique skills to the United States, where if you objectively measure them against 100 other applicants, they're the best? Don't we want to keep that person? Don't we want to have some program where we attract those people and get them to become Americans?
Oh, sure. And we do have visas for people who have exceptional abilities. That's how all these actors and engineers or have, special abilities have immigrated to the United States. So we do have visas that cover that. Specifically, it's the O1 visa. And any individual with extraordinary ability can apply for that. So, it's not particularly difficult to obtain that. The 1992 OPT program, when it was started, initiated the 12-month that you stated. The 12-month part of OPT applies to anyone, whatever degree you're seeking. But as I stated here, the 2016 rule extended that for people in science, technology, engineering, and math to an additional 24. So we're talking, 3 years for STEM, and then under the 2016 rule, they also instituted a new provision that if you go to receive another degree, you can get another 3 years under that degree also. So we're talking about 6 years, which is wouldn't you know, is the typical H-1B visa duration.
So it's actually operating as if it's another H-1B visa, essentially.
That is exactly what it is. It's a guest worker program. But see, the problem here is the H-1B has protections for domestic workers, for American workers. There are quotas, as I mentioned. There's a cap on how many H-1B workers are allowed into the country every year. And there's also labor certifications. To get an H-1B visa, the employer has to petition on behalf of the employee. See, here on OPT, the OPT individual can go work anywhere for anyone. But the employer has to certify to the Department of Labor that they are going to pay a prevailing wage to the H-1B worker, and they won't displace an American worker. None of those protections exist for OPT. It's a free-for-all. They can go to work for any employer anywhere in the United States. There is no protection for Americans.
So essentially any foreign student that's here could basically qualify for this and stay for a number of years. And I guess your contention ultimately is that they compete for jobs that American students need as they're graduating as well. That's basically the bottom line of this?
That is absolutely the bottom line here. And as I've stated, we represent a group of technology workers in this lawsuit who have been displaced or have applied for jobs with these technology companies again and again and again, who are using OPT talent, and they can't get hired.
Gotcha. Yeah, because obviously, why would you when you can hire a foreign student who's been educated in the United States, by the way, and you don't have to pay Social Security taxes or Medicare taxes for them, and they're cheaper. I mean, why would you want the American student, really? All things considered, I suppose. And if that student, the OPT student, worker turns out to be really wonderful, then you could then apply for an H-1B visa for them eventually. So, I mean, it's sort of it's a win-win for the employer and for the foreign student, but not necessarily for the American worker. I can see how that plays out. So it's an unfortunate situation. Anyway, now where's the next step with this lawsuit of yours? So now it's going to, where's it going next?
Yeah, the case has been remanded back down to the district court. So we are in the U.S. District Court for the District of Columbia. And the Court of Appeals has ordered the court to hear the case. And specifically what we have alleged is they did this by rule. Okay, it's not in statute. They're not authorized by Congress to do this, and so this is our problem with this. And in fact, the 2008 rule that we got struck down, they did it without notice and comment. They just snuck it through. So in 2016, the Obama administration, after we got the 2008 rule struck down, they reissued the rule, and so we have alleged that DHS is not authorized to extend work visas to non-students. There are people here on F1 visas who are no longer in school. They're here on a student visa and they've graduated. They have no connection with the school. They're not continuing their studies. Basically, they're just a guest worker. So we are alleging it's unlawful, and the next step is the district court will analyze that.
Well, you know what, Dale? I want to thank you, as always, for coming on the program this evening and for explaining all of this to us. Very interesting topic, and keep up fighting the good fight, my friend.